You know, buying or selling a business, it's not just a transaction. It's a high-stakes game of strategy, especially in Washington state, where every move you make is tangled in a complex web of laws. Today, we're going to pull back that curtain and look at the legal tug-of-war that decides who really wins the deal.
And it all kicks off with one single critical decision. This happens way before you even start talking numbers, and it sets the stage for everything: the risks, the rewards, the whole 9 yards.
And here it is. This is the big one. Do you buy the stock, getting the keys to the entire kingdom, warts and all? Or do you carefully pick and choose only the specific assets you actually want, leaving the rest behind?
How you answer that? Well, it defines every single move that comes next. It dictates who has the power, who's shouldering the risk, and ultimately who comes out on top.
Okay, let's get into it. The first move is choosing your battlefield. Is it going to be a stock sale or an asset sale? Understanding this is absolutely crucial because this is the foundation for the entire legal battle.
So this lays out the core conflict perfectly, doesn't it? A seller, 9 times out of 10, wants a stock sale. And why not? It's a clean break. They sell their shares, they walk away, and the buyer gets stuck with every single liability, even the ones nobody knows about yet. The buyer, of course, wants the opposite. They prefer an asset sale. It lets them be picky, cherry-pick the good stuff, and most importantly, leave behind the seller's baggage. This choice is really the first and most important way risk gets divvied up.
But the strategy doesn't stop there. Even if you, as the buyer, manage to negotiate your preferred asset sale, the seller has a pretty surprising ace up their sleeve, especially here in Washington.
So you'd think the process is pretty straightforward, right? The seller's board agrees to sell, they send it over to the shareholders, and the shareholders give it the thumbs up. Everything looks like a done deal. Or is it?
This is where things can get really interesting. The buyer has already spent a fortune on due diligence, the shareholders have given their blessing, but that deal is still not locked in.
And here's the plot twist. Washington law actually gives the seller's board of directors the power to abandon the deal, even after the shareholders have approved it. If a better offer comes along or they just get cold feet, they can legally back out. For a buyer, this is a massive risk. It means you have to demand things like huge breakup fees in the contract just to protect yourself.
Okay, so let's flip the script. It's not just the seller who has hidden moves. Buyers, you really need to be aware of a huge trap waiting for you, and it has everything to do with the tax man.
It's this little thing called successor liability. See, in an asset sale, the state of Washington just wants to make sure someone pays the seller's old tax bills. And guess who they look to? The buyer, the successor. If you're not super careful, you could suddenly be on the hook for years of someone else's unpaid taxes.
But luckily for the buyer, there's a powerful countermove. It's a statutory safe harbor. The second that deal closes, you, the buyer, fire off a notice to the Department of Revenue. This starts a 6-month countdown. The state then has exactly 180 days to figure out what the seller owes and send a bill. If they miss that deadline, you're totally in the clear. Off the hook forever. It's a brilliant way to control and cap your risk.
Okay, so we've got the state rules down. But now we have to layer on the federal rules. And this is where the game gets even more complex, especially when you start talking about taxes and employee pensions.
And this right here is a classic zero-sum game. Let's say you're a buyer and you got pushed into a stock purchase. Well, you can make what's called a Section 338 election. It's a neat trick that lets you treat the deal like an asset sale for tax purposes, giving you much bigger deductions down the road. Sounds great for you, right? Well, for the seller, it's an absolute nightmare. It triggers a double tax. The corporation gets taxed and then the shareholders get taxed again. This negotiation is purely about who gets the tax break and who takes the tax hit.
And speaking of traps, federal law has a huge one for sellers, especially those with certain types of pension plans. In an asset sale, they can get slammed with these massive withdrawal liability fees from the pension fund. The only way out is if the buyer agrees to 3 really strict conditions. They have to keep paying into the pension, they have to post a 5-year bond, and the seller has to agree to stay on the hook as a backup if the buyer flakes out during those 5 years. It's a real gauntlet they have to run.
All right, let's shift gears and talk about protecting what's often the most valuable asset in the whole deal: the brand, the trademark, the crown jewels. Mess this up and the consequences can be, well, pretty catastrophic.
So you've got to follow this checklist to the letter. And the most important rule, the absolute #1 thing is that you must transfer the trademark with its goodwill. That's the reputation, the vibe, the whole shebang attached to the brand.
If you just try to sell the name by itself, what's called a naked assignment, the law can actually make the trademark totally worthless. On top of that, you've got a tight 3-month window to file all the paperwork with both the feds and the state to make it official and protect your rights.
Okay, we have covered a ton of ground, so let's bring it all home and look at the key winning moves for both sides of the table.
And here we are, right back where we started. It all comes down to this one idea. This whole strategic dance, all the moves and countermoves we've talked about, it's all built on that first massive choice: asset sale or stock sale.
So when you boil it all down, here's the scorecard. For the buyer, it's all about playing offense. Get that 6-month tax clock started right away, protect yourself with breakup fees, and really push for those tax benefits. For the seller, it's about defense and leverage. Push hard for that clean stock sale, don't be afraid to use that statutory right to walk away as a bargaining chip, and make darn sure the buyer takes on all those pension duties. It truly is a legal tug-of-war from start to finish.
So you did it. You navigated this insane legal maze. The deal is signed and closed, you won. But here's the final question. Winning the negotiation is one thing. How do you make sure the real value you just paid for, the people, the culture, the secret sauce, doesn't just get up and walk out the door tomorrow?